GR number 165389, National Labor Relations Commission, Jose I. Ilagan Jr. and Constantino C.O. Jr. Respondents. Decision. Austria Martinez J. assailed in the present petition for review on certiorari under Rule 45 of the Rules of Court is the June 21, 2004. Edition 1, September 14, 2004, Resolution 2 of the Court of Appeal CA and CA GRSP number 78870. The facts of the case are as follows. Jose Lagan Jr. and Constantino Co. Jr. Private respondents were among 21 Filipino seamen hired by Rain Petitioner NFD and International Manning Agents INC and FIDI to work on board the chemical tanker MT Lady Helen, a vessel owned and operation by Petitioner AS Volcanoes Oslo Volcanoes. NFD foreign principal on February 11, 1997, while Lady Helen was at Islands Viewport, Durban, South Africa. Ship's master Captain Steiner Anderson dismissed the 21 Filipino seamen, including her private respondents, from other employment. They were subsequently arrived in the Philippines on February 15, 1997. On March 3, 1997, NFD filed before the Adjudication Office of the Philippines Overseas Employment Administration POEA a disciplinary complaints against the 21 seamen, alleging that they were guilty of mutiny, insubordination, desertion, attempting to the desert vessel, and conspiracy. Subsequently, in an order 3 date October 12, 1999, the POEA Adjudication Office dismissed the disciplinary complaint filed by NFD, ordering that the same of the 21 seamen be removed from the POEA watch list. Meanwhile, on May 6, 1997, private respondents together with 8 complainants of the 21 seamen whose employments were terminated filed with the National Labor Related Commission and NLRC, National Capital Region in Quezon City, a complaint for wrongful breach of contract, illegal and dismissal and damage against NFD and Volcanoes, contending that they were summarily dismissed from their employment without just and valid cause and in gross violation of the terms of their employment contract. They were forcibly disembarked from the vessel at the time of their discharge, and up to the filing of their complaint, they had not been paid their accrued salaries, guaranteed overtime pay, and leave pay for their summary dismissal, forcible disembarkation, and subsequent repatriation. They seek recovery of their unpaid wage and other benefits, as well as moral and exemplary damage and attorney's fees. In their position paper 5, NFD and Volcanoes petitioners contended the complainants were validly and lawfully dismissed from their employment for their acts of mutiny, insubordination, desertion, attempting to desert the vessel, and conspiracy among themselves together with the other Filipino seamen in refusing and or failing to join MT Lady Helen in its next trip or destination to Mauritius without just and valid cause. Contrary to complainants' claim, they were not forcibly disembarked from the vessel, for out of the 10 complainants had already withdrawn their complaints out of remaining 6. Complainants 5 were given the option to return to MT Lady Helen and rejoin it in its next trip to Mauritius. The filing of the complaint was merely an and afterthought of the complainants. After NFD filed cases for disciplinary action against them, complainants were not entitled to any of the amounts which they thought to recover. Instead, they should reimburse NFD for the expenses incurred by latter in connection with their valid dismissal and subsequent repatriation to the Philippines. In the reply to respondent's petition, paper 6, complainants averred that no single specific act of insubordination, desertion or attempt to desert the vessel or refusal to sail with the vessel was attributed to them. The Filipino crewman who reported investigated the allied mutiny was among those absolved of any liability by petitioners